Welcome to the second part of the lecture of the recognized project on defeasibility in law, a very brief introduction to its challenges. As I mentioned before, my name is Lucas Misseri, and I work as an assistant professor at the Department of Philosophy of Law at Alicante University, Spain. In the previous part of this lecture, we dealt with some definitions and historical background of the concept of defeasibility, some standpoints that consider defeasibility an essential feature of law, those that reject that claim, and those that nuance it by claiming defeasibility is more an attitude about how to treat rules. At the end of the first part, some aspects of the debate about defeasibility rules and principles were mentioned but not developed. In this part, I'm going to elaborate on that relationship using as a source Manuel Atienza and Juan Ruiz Manero's chapter Rules, Principles, and Defeasibility as appear in the volume edited by Ferrer and Ratti I mentioned in the part 1. In some way, the chapter summarizes the key aspect of Atienza and Ruiz Manero's positivist theory of law as appearing previously in Spanish in their books Las piezas del derecho and Ilícitos atípicos. Las piezas del derecho appeared in 1996 and it was translated into English in 1998 as A Theory of Legal Sentences in Springer. But I think ilícitos atípicos is not translated. It could be something like atypical, illicit, or unlawful acts theory. Okay, let's address this post-positivistic view on defeasibility. One of the first authors in using the term legal post-positivism was Neil McCormick. Among the many legal scholars that are usually associated with this term are also this Scottish author, but the famous American legal philosopher Ronald Dworkin, the Argentine Carlos Nino, the German legal philosopher Robert Alexi, and of course in Spain, the authors that we will discuss in a minute, Manuel Atienza and Juan Ruiz Manero. The Spanish scholars consider post-positivism a theoretical need, although they accept the thesis of the social sources of law as the positivist legal scholars. That justified the part of the term that is positivistic. And the post is because they question the separation thesis between moral and legal realm. That is why it's not a surprise that in that chapter I'm using as a source, many of their criticism is directly, explicitly against exclusivist positivism. Atienza and Ruiz Manero considered Dworkin's criticism on positivism seminal, and how this American author raised awareness of the fact that rules have an underlying justification, and in his regard, purposes and values intended to be served by those rules are themselves part of the law. Furthermore, they have a certain priority over the rules, which are merely means to implement them. To claim their priority implies that the meaning and scope of the rules ought to be interpreted essentially under the light of those values and purposes. That is, the demands derived thereof might justify introducing certain exceptions which are not contemplated in pre-existing rules. That's our topic, defeasibility. Those rules will then be defeated, or whenever rules are silent or generate incompatible duties, those values and purposes make it possible to determine the content of pre-existing legal duty. For Atienza and Ruiz Manero, law appears first of all as a mechanism where practical disputes and controversies are decided within a limited time period by means of authoritative decisions that involve, of course, rules. By being so issued, they provide us, at least initially, with pre-existing solutions for an unlimited number of individual cases. However, another factor to take into account is the reduction of complexity. That is could be considered the last element to complete the set of definitional properties of law or legal system. Our Spanish authors affirm that there cannot be law if there are no rules. Such a system, very much like the one imagined by Plato in his Republic in the ancient time, a system conferring absolute discretion to dispute resolution organs, would not meet the demands generally associated with the terms law or legal system. Notice that they do not derive a special essence of the word or the concept to try to reconstruct how it's considered as law. Nevertheless, there are reasons to regard law not merely as a matter of rules, but also as a matter of explicit and implicit values and purposes. One of the main reasons is to avoid serious value flaws. For an exclusivist positivist, Atienza Ruiz Manero said that law is regarded exclusively as a set of indefeasible rules. They use Reagan's terminology, where an exclusivist positivist will consider law as compounded by indefeasible rules. Those rules are opaque to principles, to the principles that justify them, that in some way are their grounding. On the extreme pole, the non-positivist would consider all rules defeasible, and rules would be transparent to principles. in some way, Atienza Ruiz Manero is trying to consider that not the rules are not strictly all immediately defeasible. There are institutional reasons to respect them. But there is a need of balance between the pole of rules associated with the idea of predictability, of reduction of complexity, and the pole of principles of the idea of coherence with the inherent values. I noticed that on the slide there's a typo, there's a mistake. The principle should be on one of the on the right arrow. Okay. This Manero find that one of the fundamental criteria to evaluate a theory of law is to test its ability to give account of how and at what point along that spectrum the tension between what can be called the pole of rules and the pole of principles. And that should be articulated and solved. And that's what they try to do in their theory. They consider that law is a practice guided by purposes and values, and it has two levels, the levels of the rules and the levels of the principles. Let's see how those levels interact and how Atienza and Ruiz Manero try to save the criticism of the defeasibility of the whole legal system and the one of the relevance of one of those levels. One example could be describing how they address that relationship in the theory of the atypical acts, both unlawful and lawful. They focus on the idea of analogy, as it's important to understand how they deal with the atypical acts. They both agree that they can start from this classical distinction between analogia iuris and analogia legis. Both involve a weak permission at the level of rules. This means that a particular action is prima facie permitted since it cannot be subsumed with any prohibitory rule. The operation of a deontic status conversion, however, differs from one case to another. In the case of analogia legis, the reason for the eventual prohibition, all things considered, rests on the resemblance between the unregulated case and another case or several other cases in which a certain prohibitory rule is involved. A justification for this is that the reasons, the balance of principles justifying the prohibition in these latter cases also apply in the case that appear as not regulated. In other words, put it simple, that balance between principles claim to generate a new prohibitory rule within which the particular act is to be subsumed. In the case of analogia iuris, the generation of a new prohibitory rule is directly claimed by the balance among the relevant principles that apply in the case. although no pre-existing prohibitory rule under which other similar cases are to be subsumed is provided by the system. A second mechanism, which applies in the case of abuse of right, fraud on the law, and misuse of power, is of particular concern for Etienne and Ruiz-Manero, and it works as follows. The starting point is the previous existence of an explicit permission. Consequently, the action is prima facie permitted by a regulatory rule, the strong provision. The modification of the deontic status of that particular action occurs as a consequence of the incoherence. You remember the pole of principles linked to coherence. The incoherence subsequently manifested between the case subsumed within the rule mentioned and the principle of the system. Hence, the case constitutes what they call an axiological gap, a value gap, in the system of rules. Here, the balance among principles argues for the generation of a new prohibitory rule within which the case is to be subsumed. The definition of an axiological gap is inspired in Acheron's and Boligin's celebrated book Normative Systems. Despite their different approaches, they held and it is adapted to the idea of principles of being part of law and not something external to it, ideological or political. Etienne and Ruiz-Manero's definition of an axiological gap is like this. A case constitutes an axiological gap in a particular legal system if and only if, first, in the system there is a rule that establishes a solution for the case, and still, second, that rule does not consider as relevant a given property which, according to the demands entailed by the balance of the applicable principles in the particular legal system, should be considered. The existence of these atypical unlawful acts respond to a demand for coherence claimed by any legal system. What is at stake is a demand for a proper fit between the directed dimension of the law and its justificatory dimension, that is, the request for integrity of rules and principles. Some systems claim, Etienne and Ruiz-Manero, clearly, civil law systems achieve this goal by way of implementing the above-mentioned mechanism. Analogy on the one hand, and abuse of rights, fraud on the law, and misuse of power on the other. Analogy plays an important role in other systems, common law systems too, but their function equivalent to those other civil law concepts according to Etienne and Ruiz-Manero can probably be found in the technique of distinguishing or in plain resort to principles. In this sense, it may be advanced that the category of atypical and lawful acts is general to all developed legal systems due to its significance as a necessary means for sparing us from extreme formalism in the application of the law. For extreme formalism would entail nothing but a sort of value and coherence of legal decisions. Therefore, the three concepts comprising the general category of atypical illicit acts, this is abuse of right, fraud on the law, and misuse of power, share the following features. A. There is an action which is prima facie permitted by rule. B. Either intentionally or not, an injury or damage is caused by that action. C. The unlawful character of that damage is shown up in the light of the balance of the relevant principles of the legal system, and D. The creation, as a result of that balancing of a new rule limiting the scope of the former rule, since the new rule considers as forbidden certain actions that were permitted under the former. But if there are atypical and lawful acts, Etienne and Ruiz-Manero also acknowledge the existence of atypical lawful acts. In this case of atypical illicit acts, in the case of atypical illicit acts, either a weak permission when a rule is provided in case of analogy, or a strong permission when there is a pre-existing permissive rule in case of abuse of right, fraud on law, or deviation of power is defeated. In its turn, in the case of atypical, licit, or lawful acts, a prohibitory rule is defeated because the damage the prohibitory rule is trying to avoid either is not produced For instance, let's imagine the example provided by Atienza Ruiz Manero is a park where it's prohibited to drive vehicles, but after closing times, there is no point on that prohibition. Or they said it's compensated by a superior good. For instance, imagine that very park during open time, an ambulance needs to go through. So that's a justified exception. Or C is insignificant. And here the example provided is that drug dealing cases when the substance in question is dramatically deneutralized or it's a very low amount. So this is, broadly speaking, the theory of atypical acts by Atienza and Ruiz Manero's post-positivistic theory. There is an objection raised by Italian legal scholar Bruno Celano, who says that the approach implies an overvaluation of principles and an undervaluation of rules, to the point that those rules seems irrelevant. He says, I quote, what depends on rules is just the possibility of ascribing lawful or unlawful behaviors, depending on their conformity or not to the relevant principles, the inconsequential label of typical or atypical. End of quote. The purpose of Atienza and Ruiz Manero category of atypical, unlawful, or lawful acts is to give adequate account of the defeasibility of the pre-existing permissive or prohibitory rule when the solution to a case it generates turns out to be axiologically anomalous to an intolerable extent. As explained above, it is a type of reasoning that leads us from the pre-existing rule to a new rule. Because one of the primary roles of principle, it must be remarked, is to generate new rules. The whole purpose of Atienza and Ruiz Manero, with their theory of atypical acts, is the institutionalization of defeasibility in the law. But one could ask how legal operators and legal scholars know that an outcome is axiologically anomalous. And that would involve discussing some of the metaethical background of Atienza and Ruiz Manero theory. For instance, Manuel Atienza's minimal objectivism, minimal moral objectivism. But that is a topic for another lecture. Thank you very much for your attention. I hope you have learned something from this lecture. Otherwise, I would feel terribly defeated. Thank you very much.